Thank you, everyone, so much for joining us for the final part of our telehealth risk management series. This session is going to focus on protecting the telehealth consumer in FTC and state-based considerations. For those of you who've been able to join us for other segments of this series, we hope you found them insightful. The goal of today's program is to focus again in the telehealth context on current key notable considerations regarding consumer protection in telehealth. Just by way of quick introduction, my name is Jian Chen. I'll be the moderator for today's program. I'm a partner in the DC office of the Health Industry Advisory Practice Group at McDermott, where I advise a range of clients, including telehealth companies, providers, and digital health companies on privacy, data strategies, as well as research compliance. And before I introduce our key speakers, just a little bit of housekeeping. If you are requesting CLE credit for any jurisdiction, you do need to participate via laptop or computer and not by phone. Participating by laptop or computer lets us track your participation, which is necessary for CLE credit. And you will also have to complete the program evaluation and include your jurisdiction and bar number. If you are requesting CLE credit in New York, please listen to the end of our presentation where we'll be giving out the secret code that's necessary to obtain the CLE credit, and be sure to get that code and enter it into your evaluation. And if you have any questions as we go along the program, which we hope you do, please feel free to type it into the Q&A function in the webinar toolbar, and we'll do our best to get back to you either during the webinar or in follow-up. And now let me introduce our key speakers for this program. Brian Boyle is a partner in our regulatory group based in DC. He represents clients in federal and state consumer protection matters with a particular focus on FTC and state investigations, as well as consumer protection litigation. Our other key speaker for today is Matt Sin, who is an associate in our Health Industry Advisory Practice Group in Chicago. Matt advises a broad range of clients, including healthcare providers, digital health companies, and technology companies on a range of federal, state, international privacy and data security laws, as well as complex commercial contracting matters. So with that, it's my pleasure to hand it off to Brian, who will be kicking things off today.
Great. Well, thank you very much for that kind introduction, and thanks everyone for joining us today. I'm looking forward to this conversation. I hope you all are as well. As most of you know, there are a wide range of legal considerations that affect telehealth and digital health more broadly. Certainly state laws specific to physicians, the practice of medicine and prescribing. There are dozens of federal laws that also apply, including laws that regulate controlled substance providing, privacy and security, certainly fraud and abuse. Of course, the Health Insurance Portability and Accountability Act, HIPAA, is critically important for many companies in this space. And we have covered, the McDermott team have covered a number of these topics in our prior presentations in this webinar series. Today, what we want to do is talk with you for about a few issues that may not be as obvious as HIPAA, for example, to make sure that you're aware of them and able to spot potential risks in your business. Can we have the next slide, please? And the next one. Great, thank you. So the first issue that we're going to talk about today is FTC and state privacy considerations. Following that, we will discuss advertising issues in the context of telehealth, as well as social media, online reviews, and then a number of issues related to engaging with users in the digital environment. Can I have the next slide, please? So I'd like to start out today by talking for a few minutes about the Federal Trade Commission and its role in privacy and data security. Next slide, please. The FTC is an independent federal law enforcement agency with broad antitrust and consumer protection authority. Although there is no comprehensive federal data privacy and security law in the United States along the lines of GDPR, for example, the FTC uses its authority under Section 5 of the Federal Trade Commission Act in this space. Section 5 broadly prohibits unfair or deceptive practices. The FTC applies that aggressively in the privacy and data security space. The FTC uses both its unfair and deceptive prongs of its authority in these cases. For example, the Commission has for a long time employed the theory that organizations' representations or omissions about data security were, quote, deceptive in the sense that they misrepresented the true nature of the protections. The FTC also challenges data security practices on the theory that the practices themselves are unfair because they're inadequate. In addition to this Section 5 authority, the FTC also enforces other statutes related to consumer privacy. It enforces, for example, the Children's Online Privacy and Protection Act, COPPA, which regulates the collection of information from children under 13. And another key statute is the Gramm-Leach-Bliley Act, which specifies privacy obligations for financial institutions. Keep in mind that the FTC does all of this in parallel with other agencies' enforcement of other privacy statutes, such as, again, HHS's enforcement of HIPAA. Can we have the next slide, please? As part of this Section 5 enforcement authority, the FTC has issued a significant amount of guidance about what it expects from companies in terms of privacy and security. And a lot of this is drawn from prior FTC cases from which the FTC has extracted kind of key points that they've distilled down into guidance for companies. And it is issued specific recommendations for digital health companies and mobile health apps. And I think it's important to have at least a high-level understanding of these concepts so that you understand upfront what the FTC would be looking for in the event that there was ever an investigation. And we could, frankly, spend the entire hour on this slide, but I think in brief, anyway, the first of these expectations is to minimize data. And this is simply the concept that if you don't collect data in the first place, you don't have to go to the effort of securing it. Secondly, limit access and permissions. And this includes things like choosing privacy protective default settings to make it easy for consumers to protect their privacy. The FTC expects you to keep authentication in mind. So implement strong password requirements, for example, and make sure that passwords are stored securely. And consider the entire ecosystem. And in the context of telehealth, that often means the mobile ecosystem. This includes things like ensuring that third-party service providers are protecting your data and building that expectation into your contracts with those third-party service providers. It also means being cautious when using third-party code, which many companies do when developing their platforms or improving on them. Another important expectation is to implement what the FTC refers to as security by design. And this includes things like developing a culture of security at your company, taking steps like using appropriate encryption, and staying on top of new threats that are emerging, which of course seem to change every day at this point. It also expects companies to adhere to best practices. And this means taking advantage of available resources, things like the Computer Security Resource Center from the National Institute for Standards and Technology. As the FTC has put it, they don't necessarily expect companies to reinvent the wheel. There are a large number of resources available out there to help companies be secure, and they expect companies to avail themselves of those resources. Communication is always a core issue for the FTC. It's something that they're very focused on. And in this context, the FTC wants to make sure that you're communicating with patients or consumers about privacy and security in a clear and simple manner. The watchword is always transparency. So the FTC expects you to be transparent, and then when you make representations about privacy and security, about the way that that particular data will be used, the FTC expects you to rigorously adhere to those representations. Finally, as I've alluded to a few times, There are, of course, a mosaic of other laws in this area, and the FTC expects you to adhere to them and to be aware of them. And so it's important that you work with counsel to identify the laws that you are subject to. And this includes the FTC Act, but also may include laws like HIPAA, the Food, Drug, and Cosmetic Act, and others. Could I have the next slide, please? The FTC tackled some of these issues in a high-profile case that concluded earlier this year. The FTC alleged that a fertility tracking app called Flow shared consumers' health information after promising not to. The case is a reminder that even if you're not subject to HIPAA, as Flow Health was not, you may still have important obligations with respect to the privacy of health information. And this case is also an important reminder because the Democratic commissioners issued a separate statement saying that they would have also charged Flow, in addition to violating the FTC Act, because of the way that they shared consumer data, they also would have charged the company with violating the health breach notification rule, which requires notifications to consumers in the event of certain unauthorized disclosures of health information. I will talk more about that rule in a moment, but it's important, I think, to pause here for a moment to underscore that we can expect the FTC under the Biden administration to actively enforce the health breach notification rule. And so this is something that you should carefully examine and consider how it may apply to your business. Next slide, please. So, of course, in the world of digital health, we're often talking about significant amounts of personal medical information online. And for most hospitals, doctors' offices, and insurance companies, HIPAA governs the privacy and security of health records stored online. But many web-based businesses that collect people's health information aren't necessarily covered by HIPAA. These include online services that people use to track their health information, and can also include online applications that interact with those services. The FTC has issued the health breach notification rule to require certain businesses not covered by HIPAA to notify their customers and others if there is a breach of unsecured, individually identifiable electronic health information. And this exists, again, in parallel with the HIPAA breach notification rule. The next slide, please. So exactly what notices are required by the rule depends on the nature of the breach. Generally, if you experience a breach of unsecured personal health information, you have to notify each affected person without unreasonable delay and within 60 days after the breach is discovered. If the breach involves information of 500 people or more, you have to notify the FTC as soon as possible and within 10 days. And so this is obviously a very short deadline, and makes it extremely important that you act quickly in response to any breach, and frankly, act quickly to determine the scale of any breach. If the breach is smaller, if it involves fewer than 500 people, you have more time to notify the FTC, in fact, significantly more time, but there's still a notification requirement. And additionally, for large breaches, you also have to notify the media. The rule includes specific requirements. In addition to who and when you have to provide notifications, it also requires how the notification must be given, and what must be included in the notification. And it's important to think about these issues in advance and develop a plan so that you have something that you can pull off the shelf and act quickly in the event that a breach occurs. Next slide, please. Of course, in addition to FTC requirements with respect to privacy, state law plays an enormous role. State privacy laws are proliferating. This year, there's a tremendous amount of interest in state capitals across the country in passing new privacy and data security related laws, in many cases modeled after California. And it's important to closely monitor these developments, understand what the laws are in your jurisdiction, meaning any states in which you operate, and make sure that you're staying abreast of any changes. Keep in mind as well that some of these statutes, for example, the CCPA, although they exempt generally personal data protected by HIPAA, they may cover other personal data that's created or processed by healthcare industries. And so it's important that you not simply assume that you're not subject to some of these laws because you may be subject to HIPAA. It's important to do a deep dive, carefully evaluate the data that you have and how you're using it, so that you can be sure that you're certain about what laws you are and are not covered by. Move the next slide, please. So now that we've talked about privacy, we're going to turn our attention to another core area of consumer protection, which is advertising. Next slide. The most fundamental principle in advertising law is that advertising has to be truthful and not misleading. Keep in mind that many ads can be interpreted in many ways. And if that's true with respect to a particular ad, each reasonable interpretation must be true. The claims that are made in ads, including implied claims, have to be substantiated before they're made, in advance, not after the fact. In addition to the individual claims, remember that the net impression of the ad must also be true. Additionally, the ad cannot be deceptive, for example, by failing to disclose material facts that would be necessary to not create a false impression. Keep in mind also that in the context of telehealth, many states have laws that specifically regulate physician advertising, and it's important that you fully understand those laws in all states in which you operate. Next slide. So what is required for claim substantiation? What does that mean? Well, the key point is that claims in advertising, as I said a minute ago, have to be substantiated in advance. And that means that you have to have a reasonable basis for them before you run the ad. If your claim specifies a specific amount of support, for example, saying studies show or 9 out of 10 doctors agree or something like that, then you need to have that specific level of support for the ad. Next slide. Additionally, and this is critically important, in the context of health and safety claims, you need to have a very high level of substantiation. These claims are subject to the greatest degree of scrutiny. They are the most likely to be subject to proceedings before the National Advertising Division, and they're the most likely to be subject to FTC enforcement. Health and safety claims require competent and reliable scientific evidence. You cannot simply rely on anecdotal evidence from patients, for example. Next slide. Keep in mind also that in addition to being adequately substantiated, claims also cannot be misleading. This means things like ensuring that you include appropriate context, not suggesting that non-clinical data has clinical significance if that hasn't been established, not using things like pictures or graphical material in a misleading manner. And finally, keep in mind that in addition to substantiating claims, it's always important to present them in an honest way. Again, the net impression of the ad at the end of the day has to be truthful. Next slide, please. Certainly a key area where advertising issues are playing out right now is social media. And both the FTC and the FDA are very focused on this. Next slide. Most of us have become very familiar with social media posts like this. Celebrities and other influencers promote products on social media, and this is now extending to health-related products. But these are advertisements subject to federal law as much as any other ad. That means for products regulated by the FDA, influencers have to adhere to FDA rules. For example, in this case that involved Kim Kardashian, the FDA objected that the language of the post, among other problems, was misleading because it failed to communicate any risk information associated with the product and omitted material facts. This also means you have to adhere to FTC requirements. Next slide, please. The FTC's requirements for social media are governed by what's called the Endorsement Guides. And this requires that endorsements cannot convey or express claims that would be deceptive if the advertisers made them themselves. In other words, you can't hire Kim Kardashian or someone else to say things that would be improper if you said them directly. Again, you have to have adequate substantiation for all of the claims in the ad, regardless of the fact that they're made through an endorsement. The endorsements have to reflect honest opinions, findings, and beliefs of the endorser. And a key aspect of that is that if someone is claiming to be a user of the product, they must have, in fact, used the product. You can't lie about that. Lastly, and perhaps most importantly, because it's an area with a significant amount of enforcement right now, is that the post must disclose any material connections between the advertiser and the endorser. Next slide, please. So what do I mean by disclosing material connections? Well, in layman's terms, this typically means that influencers who are compensated or have a stake in the company have to disclose that the post is an advertisement. Of course, unlike watching TV, where it's typically easy to tell when the program stops and the advertisements begin, in the social media world, if you're scrolling a Facebook feed or an Instagram feed, it can be very difficult to tell what's an advertisement and what isn't. And so that environment is ripe for deception. And the FTC has issued very specific guidance for social media endorsements about how they expect influencers to disclose any connections that they have to the advertiser, to the product that they're endorsing, to the service that they're endorsing. And typically, what that requires is a clear and conspicuous disclosure, generally using the industry standard is to use #ad. And importantly, that has to be clearly displayed before clicking more, right? So you can't bury it down, down deep in the caption of a post, or hide it in the middle of a number of different hashtags. It should be right there, ideally right at the beginning, and always in the first 2 to 3 lines. And of course, the idea here again is to make it easy for consumers to understand, okay, this is a paid ad, or this is a post by someone who has a financial interest, for example, in the in the product, in the service that they're advertising. The last point on this slide here, I think, is very important from a practical perspective, and that is to make sure that you're including, if you're going to engage in this type of advertising, it's very important that you include appropriate provisions in agreements with influencers. This is something that we at Dermot do a significant amount of work in, both on the side of the celebrity endorsers and on the side of the companies. From a company perspective, it's very important that you have adequate protections in there in the event that the individuals endorsing your product don't adhere to these FTC guidelines. And it's also important to consider steps like adequately monitoring these posts. Next slide, please. A similar issue to be aware of is online reviews by customers or by patients. Next slide. As I mentioned a few minutes ago, Section 5 of the FTC Act broadly prohibits unfair or deceptive acts or practices. When it comes to reviews, that means several things. First of all, you cannot suppress negative reviews. Can't hide them or secretly provide incentives for reviews without disclosing them. The bottom line is that consumer reviews of your telehealth service, your digital health app, whatever the case may be, have to be honest without you putting your thumb on the scale without disclosing that to consumers. Next slide, please. In addition to the FTC Act, there's a federal law called the Consumer Review Fairness Act, which makes it illegal for companies to include certain standardized provisions that threaten or penalize people for posting honest reviews. The act makes it illegal for a company to use these types of provisions to bar or restrict the ability of a person to review a product, to penalize someone, or to require someone to give up their intellectual property rights in the content of their reviews. This doesn't mean that you as a company have no rights with regard to your reviews. There are certain things you can do. You are permitted to remove reviews that contain confidential or private information, for example, that are reviews rather that are libelous, harassing, that are clearly false or misleading, that sort of thing. But it's important that if you're considering altering reviews at all, I would highly recommend that you seek legal counsel and make sure that you're doing it in an appropriate way, in a way that's not going to run afoul of the FTC. The last thing that I will note is that it's important to keep in mind with advertising and with the world of social media and online advertising in particular, that your advertising can implicate a wide range of other consumer protection issues, including restrictions on sweepstakes, lotteries, and other things. And so, again, always make sure that in this context, you're seeking out in advance appropriate legal advice at the planning stages of any kind of advertising campaigns in these media. And so with that, I'd like to, next slide, please. And I'd like to turn it over to my colleague, Matt, who's going to talk about a series of issues that relate to engaging with users in the digital environment.
Thanks, Brian. We thought it would be particularly relevant and helpful. I don't know if it's given the pandemic or hopefully transitioning through the pandemic, as our clients have tried to find ways to continue to engage with their customers, patients, and other users, most of which happens to be sort of in this digital environment, all online, text-based, web-based. We thought it'd be helpful to walk through some considerations and sort of the legal ecosystem, if you will, for how to operate in this space. If you can advance to the next slide. Perhaps the most prevalent, seems like lately, is a text-based or phone-based communication. Many of our telehealth clients are regularly looking for innovative ways to communicate with their customers, and it seems like automated texting has become quite popular in the sector. So with that, it's important, I think, to highlight the TCPA, so the Telephone Consumer Protection Act, is the federal law that regulates the sending of automated or pre-recorded phone calls and text messages. The TCPA has, this will be a brief summary, but the TCPA has different levels of consent, depending on whether you're sending a message or a call to a wireless or a landline phone number. The consent can vary depending on the technology you're using to make the call or the text message. And then perhaps most important, the consent depends on the content of the message you're sending. And we'll unpack that a bit in the next couple slides, but the difference really is whether it's a marketing or promotional message, or whether it's a informational transactional message related to something that's ongoing between the business and the user. Some other highlights of the TCPA include prohibitions on calling residential numbers at certain times of the day. And perhaps most important, the opt-out. Honoring opt-out requests if consumers no longer want to receive those messages, because as everyone knows, they can be quite annoying. It's worth highlighting this point particularly is that the TCPA is probably one of the most heavily litigated privacy laws in the US, in part because it has a statutory private right of action with statutory damages. There's two different levels of damages. The lesser standard is $500 for negligent violations, and then $1,500 for knowing or willful violations. And that can be per text message. So if you shoot out a blast text program and you don't have the appropriate consent, you're looking at a significant risk of damages. The other reason I think it's probably most heavily litigated is because it's pretty easy to get tripped up on it. You have to make sure you have the appropriate consent. If you're using a vendor to manage the program, you have to make sure they're honoring any opt-out requests. So it can be easy to trip up with significant penalties. In the next slide, we'll talk about the different levels of consent, but I think it's also worth noting, particularly for this webinar, that there's 4 exemptions to the consent standards relevant to the health sector. So there's a healthcare messages exemption. So for HIPAA covered entities and business associates, if they're delivering healthcare messages, there's pathways to not have to meet the highest standard of consent. Again, as long as the call or the text message concerns a health-related product or service, and there's an established business relationship with that patient, and it addresses that patient's healthcare needs, there's a pathway to avoid the higher standard of consent. There's a second exemption called the healthcare treatment purpose exemption. And the FCC established this one when there's an exigency and a healthcare treatment purpose needed. This one's not as helpful because it's pretty burdensome to meet, but I pointed out just because of the relevance. The reason it's burdensome is because the message must be free to the end user, so it cannot impact their data or message charges. There's caps on how many messages you can send. So 1 message per day and up to 3 messages per week, which can be restricted depending on what the program is needed for. There's character limits. If it's a text message, up to 160 characters. Or I think if it's a phone call, the message has to be under 1 minute long. And there can be absolutely no telemarketing in that message, otherwise you lose the exemption. The third exemption is an emergency purpose exemption. And this one is, they define the term emergency as anything necessary that affects the health and safety of a consumer. The courts, it seems like they don't define this one well, but they kind of say, like, when you see it. When there's an emergency, you sort of just know it when you see it. The last one that can be relevant for some clients or some of our organizations in the health sector is a tax exempt nonprofit exemption. So calls made by or on behalf of a tax exempt nonprofit organization do not require the highest standard of consent. And I'm going to unpack those in this next slide now. So if we can advance.
And Matt, if I could just add quickly one point there, something to be aware of with the emergency exemption, because over the past year in the context of the COVID-19 pandemic, that's something that Matt and I and many of our colleagues have spoken with a lot of clients about. It's important to be aware and keep an eye out for FCC guidance on the application of these exemptions. From time to time, the FCC will issue guidance on how the exemption applies to a particular circumstance, such as the COVID-19 pandemic. And it's important to carefully consider any guidance like that and how it may apply to your business, and not simply assuming, okay, because, for example, it seems like we're in a emergency type situation with COVID-19 that, I can clearly rely on that exemption.
Great. Before I dig into the different standards of consent, it's also just worth highlighting that the TCPA only applies to text messages that are sent using an auto dialer. And there's been some recent activity in this space. As recently, there was a Supreme Court case involving Facebook, and it significantly narrowed the definition of what an auto dialer is. Essentially, not just using an automated system to text, but a system that actually uses a randomly generated, a system that can randomly generate numbers, so either sequentially or randomly. That's the limit on what an auto dialer is, at least at the moment with the Supreme Court, which may be why you, as consumers, you get you've seen an uptick in the amount of text messages you get, because it's sort of really shrunk down the scope of how the TCPA applies to text messages. We're still cautioning and recommending our clients to take a very conservative approach here, because we think it might be likely that Congress will amend the TCPA, or the FCC may take a different approach in how they give guidance on this point, but we still recommend, if you're using an automated system, to still obtain one of these two consents and to otherwise comply with the TCPA for the time being. So as you see on the screen here, there's two standards of consent. On the left-hand side, there is what's called the prior express consent requirements. This only applies for informational messages. For example, information that relate to an ongoing transaction, whether it's a transaction receipt if you paid for something, or appointment reminders or prescription reminders, something that's sort of an ongoing relationship with the patient. This standard of consent is very low in terms of what you need to achieve that consent. The FCC and many courts have interpreted this to mean any written or oral consent, so it does not have to be written. As part of this express consent standard, some courts have even concluded that when you knowingly provide a phone number to a business, you're impliedly consenting to receive some sort of communication from that business, right? If I give my phone number, I'm not giving it for no reason. I'm giving it because I want you to send me something or communicate with me in some fashion. The important piece on this, though, is even if it's an oral consent, record keeping is critical. So in the TCPA, in the event of a dispute, oftentimes the sender or the defendant will have the burden to prove that it had the appropriate consent. And with implied consent, if there's no context given when you give a phone number, it's hard to tell what the scope of that consent was. Was that phone number given just for prescription reminders or appointment reminders? Was it given for surveys about your satisfaction in the health system or at your provider? Was it given to receive advertisements and promotional text messages? So it's important to have some sort of context in the event you need to demonstrate what the consent was for. On the right-hand side is the more enhanced consent. And this is the consent that's needed in order to send telemarketing messages. The term telemarketing is defined to include any message that encourages the purchase of, the rental of, or the investment in property, goods, or services. We recommend that you take a very broad interpretation of that definition. So anything that's advertising or promoting a product or a service in any way, you should just take a conservative approach and meet this standard. This one, again, as it says in the title of the consent, is written, you must have an agreement in writing before you send a telemarketing call or text message. When we say writing, you can still have an electronic consent pursuant to, or as long as you're complying with e-sign, but it cannot be an oral consent. As part of this consent mechanism, you have to have a clear authorization to send automated messaging, and particularly for telemarketing purposes. It's important that the authorization is to send automated messages for marketing purposes. In terms of where the consent mechanism should be presented to the consumer, the consent should be clear and conspicuous, not sort of buried in the terms of use or combined with other notices. It should be sort of upfront, clearly distinguished from other notices in the user interface. And we would recommend having sort of a checkbox, an unchecked box that they must check in order to opt in to receive those messages. The last sort of requirement of the opt-in or the consent, and I'm sure you've seen it before when you're just sort of registering for services as a consumer, is there should be language that says that the purchase or use of a service cannot be conditioned on providing consent. Usually it says something like, consent is not a condition of purchase. Some examples of how to implement this enhanced standard of consent can be in a sort of on a paper form, pen and ink, or an electronic signature, again, in a graphically distinct consent form, or what I just described with the unchecked box on a website, a separate electronic consent with an unchecked box pursuant or conforming to the e-sign Act, which I'll cover a little bit later in this presentation, but that's what gives credibility and weight to an electronic signature in the same way of a physical signature. Again, just the last sort of best practices point is it's important to have really good record keeping here on consents and opt-outs. because again, the sender has the burden to prove it had the appropriate consent and that it didn't text someone who actually requested to opt out. So if you have lots of different vendors managing different text programs and different short code numbers, it's important to have sort of a master list of who's still opted in and who is opted out to make sure that all the different vendors managing different programs are sort of maintaining that like master list. We can go to the next slide. Another frequent way that businesses are communicating with patients and customers is via email. So I thought it would be pertinent to talk about the Canspam Act, which is another federal law, and that regulates the sending of commercial emails. It applies to any electronic message which delivers a commercial advertisement or promotes a product or service. The important points here are the terms commercial versus any sort of transactional or relationship message. So the carve-out, so the scenarios in which emails are not subject to Canspam are when emails are facilitating a commercial transaction that the patient or the consumer previously entered into, like if an email has purely and solely just a receipt with no advertising or promotional information in it, just like an email acknowledgement. That would be more transactional, not a commercial promotional message. Some other examples are maybe not necessarily relevant to the health sector, but just to give some context. If an email had a warranty information or product recalls, a notice about account balances, information about employment relationships or benefit plans, or even just to deliver goods or services, those would be transactional or relationship driven and not necessarily commercial driven. However, if an email has a dual purpose, here's a receipt, but it also has a promotional code or something that's encouraging you to consume more of the product or service, it may have a dual purpose. And that assessment requires you to look at what the primary purpose of the email is. You sort of literally look at what's allocated in the email. Is it mostly commercial? Is it mostly transactional? And if it comes out as the primary purpose is commercial, then you must comply with Canspam's requirements, which I'm going to go through in this next slide. And we can advance to the next slide. So here's a summary of the 7 or so key requirements of the Canspam Act. And again, I'm sure you all have noticed these things when you're just operating as a consumer and you get commercial emails. The most frequent one you'll see is the unsubscribe link at the bottom of emails. But just to sort of briefly highlight the other ones. So you have to have accurate email header information. So in the from line, in the to line, in the reply to line, you must accurately identify the entity that's sending the message. One nuance here is if you have a vendor that's sending messages on your behalf, you want to make sure that the from, the to, and the reply to lines are reflecting the actual business that the message is sent on behalf of and not just the vendor, so that consumers know who the email is coming from. Similarly, the subject line of an email must be accurate. It must accurately reflect the content of the message. So if the message talks about a promotion or some new service you're offering, the subject line shouldn't be about security. If the message is considered commercial, again, promotional related, the message should be identified in a clear and conspicuous manner that it's an advertisement. You can't, again, be deceptive in letting consumers know that it's an advertisement, similar to all the things that Brian talked about earlier in the presentation. The message at some point in the email should talk about or should include the sender's physical mailing address. And as I alluded to at the beginning here, the message must include instructions on how recipients can opt out of further messages in a clear and conspicuous manner. Essentially, it should be very easy for an ordinary person to understand and execute that opt-out request. Related to the opt-out requirement, the sender of the messages must honor any opt-out requests promptly within 10 days. I mentioned that many of our clients, many organizations use vendors for this functionality, whether it's to manage the opt-out list or to actually send the messages out themselves. But the Canspam Act restricts businesses from contracting away that responsibility. And so in the event of a violation or some dispute related to Canspam, both the sender and the business that the messages were sent on behalf of can incur legal responsibility. Just a couple of tips and things in regard to the opt-out, because it has to be clear and conspicuous. Creative uses of font size, color, location of the unsubscribe link can help improve that clarity, which is what the FTC looks for. The Canspam Act allows businesses to have what's called a preference center or menu. If you maybe send a variation of different types of messages, maybe like promotional messages, loyalty program messages, survey app messages, you can have a preference center that allows users to choose which messages they want to stay opted into and which messages they want to opt out of. But if you offer that preference center, one of the options in the menu must be an unsubscribe link from all commercial messages. A business cannot charge a fee or require a recipient to give any additional personally identifiable information other than the email address to opt out of that email. And you can't make it unduly burdensome to execute the opt-out. So Canspam sort of is, when you click unsubscribe, it should maybe go to one other landing page. And that's it. You can't be like, are you sure? Please confirm. And then sort of string them along to make them maybe exit that series of pages. Once an individual has exercised their preference not to receive future messages, the business is not permitted to sell or transfer their email addresses, even in the form of a mailing list. That sort of has to be, is an opt-out, no further messages should be sent, and it shouldn't be transferred to another business. We can go to the next slide. Another important one here just to mention is businesses sort of engage consumers in all these other ways and modalities. Many businesses have chosen to record phone calls, whether it's for training purposes, quality assurance purposes. And I'm sure you've all heard this consent. Usually when you call an airline or a credit card company, you'll hear, this call may be recorded for quality assurance purposes. That one sentence is to comply with state and federal call recording laws. So federal and state wiretap laws require the consent of some or all parties to a conversation. At the federal standard, that's actually a one-party consent. So there's one-party consent laws and two-party consent laws. So the federal standard is a one-party consent. Essentially, the caller can be the party that consents to that conversation. So federally, in at least over 35 states, that's the standard. There's a small handful of other states, maybe it's 10 or so states, require the consent from all parties to a conversation. That means the caller and the recipient or all recipients on the call must consent. And in many states, it's sufficient if the other parties to the call know that the call is being recorded and decide to proceed with the communication, even if there's not some sort of explicit consent. An example of that is just what I just read is, this call may be recorded for quality assurance. I'm not actively consenting to it, but I decide to continue on after hearing that message. One sort of tip on this one is, even if calls ever get transferred to other departments, we recommend either playing it if it's an automated message or having that representative in the transferred call also read it, so that again, consumers know that the transferred call is also being recorded. And it's also important to think about whether the message is an automated message or read by an individual like the representative. Make sure that's being done both on inbound and outbound calls. We can go to the next slide. We thought it'd be helpful as we're talking about engaging users in this digital environment, some some considerations when you're contracting with consumers. Again, as consumers, we often will click that we agree that we have read the terms of use in the privacy policy, and very few of us ever read those. But they're critical documents, and they contain very important risk allocation provisions that protect the entity in the event of a dispute or any liability. But in able to enforce those documents against a consumer, we have to make sure that we're appropriately binding those consumers or the patients or users to those documents. And there's sort of two words here. There's a click wrap mechanism, there's a browse wrap mechanism. The browse wrap mechanism, which is more so, it's a passive consent process. So a lot of websites will put a link to the terms in a privacy policy just in the footer of a website, and they're there passively, but you didn't actively click that you agreed to them. Most courts will say that a browse wrap mechanism is not an appropriate way to bind the user to the terms. Going back to sort of 1L contracts course in law school, in order to have a valid contract, we have to have a manifestation of assent to the contract by all parties. So that manifestation of assent is really important, and that's what a click wrap mechanism is. So a click wrap could be, for example, an unchecked checkbox. When you are signing up for a new account on any website, there should be a checkbox with language next to it that says something like, I agree that I read these terms of use and have consented to this privacy policy. That would be a click wrap. Another important issue that's worth raising, and there's sort of varying schools of thought on how to do this, but the question of whether to incorporate a privacy policy into the terms, whether the privacy policy is a contract in and of itself, but there may be reasons, and I think there's worthwhile reasons to keep them separate. One, for example, is that the contract, the user agreement is a contract with consideration and risk allocation provisions. The privacy policy is really just a compliance document. If it's done the right way, it's a compliance document that just sets forth how the business collects, uses, and discloses data. It doesn't have very contractual language that user promises this, the business promises this in exchange for that. It's really just a one-sided statement of your privacy practices. And there may be reasons to keep that separate. In the event of a breach or misrepresentation in a privacy policy, you maybe are not having a breach of contract. With both the privacy policy and the user agreement, you have to be careful both procedural and substantive enforceability. So procedurally, both documents need to be readable. If they're not readable, or they're in size 3 font, or the color contrast is bad, you can't enforce them, or they're not enforceable. You can't rely upon them in the event of a dispute. Similarly, you shouldn't use very heavy words. It should be understandable to an ordinary person. Substantive enforceability in the terms, there's a lot of case law right now about how to make an arbitration provision enforceable against consumers, because arbitration is seen as not very consumer friendly. So courts say if you move, or if you put a warning sort of at the beginning of the terms before the fold or before any other provisions, that can help, again, let consumers know that there's a mandatory arbitration provision and they're maybe losing some important rights, like the right to sue in court. If we go to the next slide. Another contracting consideration, as I mentioned earlier, is electronic signatures. So the e-Sign Act was enacted in the year 2000, and it applies to every state where federal law applies. And essentially, that's only in transactions that affect interstate or foreign commerce. However, in instances where the federal law does not apply, most states actually have adopted what's known as the Uniform Electronic Transactions Act, UETA. The core tenet of both e-Sign Act and UETA is that a signature, a record, or a contract cannot be denied legal effect solely because it's in electronic form. Both laws have minimum requirements to accept electronic signature, as well as certain exemptions when electronic signatures are otherwise not acceptable. think we can advance to the next slide. Now that might be the last piece I have, and then maybe we'll have a few minutes for a couple questions. The last piece I thought was important to point out here is these state and federal auto renewal laws. And this is sort of what, again, as consumers, when we subscribe to Netflix or Pandora or Spotify, they sort of charge our credit card every month automatically without us sort of actively purchasing another month. There's state and federal laws that regulate that practice, the offering of a subscription or a contract that renews on a recurring basis sort of automatically. At the federal level, the Restore Online Shoppers Confidence Act, which is regulated and enforced by the FTC, specifies that you have to have a set of provisions before you agree to that subscription model that sort of clarify the material terms of the contract, the price that will be charged to your credit card every month, clear instructions on how to opt out of that subscription model, and even having a separate, again, a separate unchecked checkbox. Similarly, several states have those very similar laws. The key is having a separate consent. You should send an acknowledgement, like a receipt afterwards that has all of the terms of the renewal service, the renewal offering, and easy mechanisms to opt out. The penalties can be significant. I've seen FTC settlements over $10 million. California's auto renewal law actually prescribes that a violation can result in the goods or services being deemed an unconditional gift. In other words, a refund of all the proceeds paid for because of the violation. So these should have to be taken seriously if you're doing some sort of renewal program like this.
And Matt, if I could just quickly add one point on this. I know I mentioned earlier in the context of state privacy statutes that there's a significant amount of new legislation emerging in that area. And that's also true in the area of auto renewals. So something like at least 12 states this year already have proposed or enacted new legislation in this space. New York in particular just passed a very onerous new law on automatic renewals. And we've seen a really dramatic uptick in federal, meaning FTC, state level enforcement, and also private litigation over these issues. So this is something worth taking a very close look at. If any of your revenue streams involve any type of automatic renewal or free trial that converts to a paid option, anything like that. And Matt, with that, I think we have a minute or two for a couple of questions.
Yeah, Matt, looks like we've got one question from an audience member about SMS texts.
Sure. So the question was, please confirm if an email unsubscribe request impacts the sending of an SMS sort of text message to that individual, if that individual has previously consented to SMS messages and has not opted out. The Canspam Act, which regulates commercial messages like emails, should not impact a text message like an SMS. The SMS, as long as it's an automated message under the TCPA, you're allowed to continue to send that person text messages. The Canspam would be a separate regulatory scheme for emails, not text messages. Great.
Well, thank you both for those insights. Really quickly, just to give those of you who are waiting for the New York CLE code, it's yellow 1, YELLOW 1, no space. Make sure to enter the CLE code when you're completing your evaluation. And thank you again for joining. We hope you found this helpful, and please feel free to reach out with any questions.
Diane, is that numerical 1 or the word 1 for the code?
Sorry, the numerical 1, YELLOW number 1, the number 1.
Thank you, everyone.
Thanks, everyone.